Good afternoon, everyone. I thank all the participants for your patience. This is a long webinar, but it's been so interesting listening to the experiences of Justice Gupta and Mr. A.J. Jawad, both with different areas of expertise and their willingness to share their thoughts and their views with us on what is the way forward in arbitration in India. Jawad is an expert mediator as well, and so we've had his insights on mediation as well. I hope to touch on some questions relating to mediation in this session. I think we will start. The idea in this session is to throw most of the questions, I think, or all the questions to both the speakers, so we get different perspectives. That gives us a more wholesome, view of the way things are on these questions. So, if I might request Justice Gupta to go first, in responding to the question, and then Jawad to do so. Jawad is an old, so I refer to him without any prefix. So my first question is on diversity. We have a great pool of talent in this country. We're really blessed. And I'd like to hear each of your views on how we can bring gender diversity into the arbitration ecosystem.
Chitra, you are right. We have a diversity of profession, the fields, and so is the gender diversity. The only question is, since we have a party autonomy, the parties firstly choose arbitrator. It's only probably in some institutions the presiding arbitrator is appointed by the institution. But in most of the institutions, it is again the chosen arbitrator appoint the presiding arbitrator. So entire ecosystem, according to me, Chitra, requires to be revamped. We have to change our mindset, not only in respect of gender diversity, but in respect of acceptability of the arbitrators across the age, gender, profession. Everyone should be eligible and chosen by the parties to act as an arbitrator.
Thank you, sir. That was a very important point, that it's, the arbitration ecosystem is reflective of how we as a society regard our women, persons of other gender. So thank you for that. Again, a reminder from Justice Gupta about what the responsibility is for each of us in this, in this seminar. Jawad, can we hear your views?
Yeah, Chitra, I think recently we had this Tribunal Secretaries program in the IAMC, and one of my colleagues, while speaking, he said that arbitration is dominated by the pale, male, and stale. So I think I fit into the category of male and stale, though I'm brown, so I can't be called as pale. But the reality is that it is dominated by people who have and it's not wrong. I don't think it's wrong in the sense that there's more faith in the experience and the expertise and all that, because there's a lot of experience that people require when you're sitting as an arbitrator. But that doesn't mean that the people who are not old enough don't have the experience or the intelligence or the ability to do that, play that role. So there are two things here. One is whether young people should be given getting the opportunity to be arbitrators. I think that is woefully lacking. I don't think it is only in India, but it's a global phenomenon as far as I understand it, because it's dominated by men with experience. So that needs to really change, because what we are seeing now is a generation of young lawyers and young people who are coming up, who bring a lot of insights and knowledge, because they have information at their fingertips today. So recognizing that, what we did in the IAMC was in April 2025, we conducted a training program for about 30 women arbitrators, for 30 women professionals who don't fit into the category of, elderly or old. Okay, so majority of them were, I think, in the age group of 30 to 40. And one or two of them were above that. So we conducted an arbitration training program for them where we brought in experts who trained them in arbitration. They were assessed for various things, drawing up procedural orders, writing of awards, how to conduct the sessions. So the assessment was done and what 28 were selected. And what we did was we created a reserve panel for them and we are giving them cases. So the cases that are coming to us, not the high stake case, because they need to get the experience to, qualify for that. So we are giving them the cases where we are giving the option for the parties. We are giving 3 names from this panel for the parties to choose. And if they choose any one, we are appointing that person. Otherwise, if the parties are not able to agree on the appointment, we appoint an arbitrator there. So we are giving that opportunity. So because we felt that we need to create the space for women to really establish themselves, because we recognize the lack of gender diversity when it comes to especially arbitration. Fortunately, mediation started off in a different way. Mediation, in fact, is dominated by women. And, more women are, successful mediators than men. And they are much better at mediation also. But where it's the arbitration field where where they are underrepresented. So we wanted to create that space. So that is, I felt that was the first step that we can take perhaps to change the equation. And as Justice Gupta rightly said, and you said that you wanted divergent views. There are no divergent views here because you'll be disappointed because most of the points which Justice Gupta has earlier said also, I agree with them. So you may not see the divergence, but we all agree that yes, that space has to be created for a better gender representation and for giving opportunities to young people also to act and shine as arbitrators. And the Tribunal Secretary program itself was conceived only to give the opportunity to young people to get exposure to arbitrations, so that when they act as tribunal secretaries, they can get that first-hand experience of how arbitrations are conducted, because they will be assisting the arbitrators in drafting procedural orders, in doing research for the awards. So in all this, that will place them in a better position to become arbitrators as they advance further in their careers.
Chitra, can I just supplement it?
Please, sir, please, sir.
Traditionally, the legal profession was dominated by male. But in the recent past, say maybe 10, 15 years, the ladies have come in a big way in litigation, maybe in adjudication as well as in courtroom litigation. You will see the difference in another 5 years where there will be many more females as an arbitrator, because they will be experienced in adjudication. So it is a matter of some years before ladies will dominate this field also.
Yes, sir. God willing, this will happen. Justice Gupta alluded to the role that institutions could play, and Jawad has explained how steps are being taken. I think there is a greater possibility for arbitral institutions to make sure that women, that there is gender diversity, that persons don't, be left out because they're not pale male and stale. So yes, so that's a way forward, I think, positive action that can be taken arbitral ecosystem. And another area where I see there is complete lack of ageism, and there is gender diversity is amongst ODR institutions. So alongside ADR institutions, we have, I think, 20 odd ODR institutions, JustAct being one of them, where there are young people of all genders who are leading in dispute resolution, in reimagining dispute resolution in so many wonderful ways. this preceded COVID. And COVID only justified the very important role that ODR institutions play around the world, and particularly in our country. So the question, taking from moving from this context was, that I wanted to ask both of you was, we have institutions like IAC, IAMC. Mumbai International Arbitration Center. And then we have several ODR platforms that are there. And these are running, I think, parallelly in redefining, in contributing to dispute resolution in India. How do we develop complementarity between these institutions? How can these institutions work with each other so that they are not working in silos? There is this perception, and I would call it a misperception, that ODR institutions are good for low stakes, high volume disputes. And I don't understand why it needs to be that way. So how can the two sets of institutions work together to build better models and frameworks for dispute resolution?
As Jawad has in the previous session has opined, that India is a big country. Probably some of the cities in India are bigger than Singapore. So we can't compare with Singapore in any way. Singapore has developed a system because of its population and low disputes. They have got arbitration disputes of around 500 in a year. And in India, there are probably thousands of arbitration disputes which come to the court, even for appointment of an arbitrator and for proceedings for extension of time, for award dispute. This volume is very different, actually, and therefore we can't say, that we can't compare the two. In respect of ODR, when I was chairperson of IAC, there are two institutions contacted us. One was a bank who said that we have a high volume cases. Can you give us discount in the fee? Says nothing doing. We have our reputation at stake. There will be no discount because you are bringing large volume. We have to decide as per the norms. And actually, we thought of that. We'll decide online, which will be much faster because the disputes are of high volume, low stake. A lakh of rupee or 2 lakhs, the truck loan or other things, that can be decided in much effective way by the ODR platform because the ODR platform is the only way to do it because of the judgment in the cases that in the central regulatory authority case, that the interested party can't be an appointing arbitrator. So therefore, all these banks, by virtue of that judgment, can't appoint an arbitrator. They have to come to the institution. And if the institutions are flooded with this kind of large volume, they have to decide. That is the only way to decide in ODR manner. I think the institutions, at least IAC, was geared up for deciding these disputes by online method. But somewhat or other, none of the institutions, there are two institutions who contacted, but they never responded back because the commercial interest, they give us discount. This discount philosophy has crept in our thought process. You ask for discount and everything. Yeah, that's all I'd like to say.
Chitra, can you see me?
Yes, Jawad. Now we are able to hear you. We were able to see you, but I think there was a lag. Now it's all right.
No, I was disconnected temporarily, so I could not really listen to what Justice Hemant Gupta said completely. So I rejoined again. I reconnected again. So sorry, I missed that whatever the part of what Justice Hemant Gupta said about this. So my perspective is that I don't see any kind of a differentiation between ODR and ADR institutions, because I feel that we have reached a point where technology has to be integrated into dispute resolution. Now, when it comes to a purely online or a hybrid method of online mixed with offline, what we need to be looking at, and how are we going to be looking at that? Because if you, for example, purely online, for example, if you take Amazon, if you take eBay, they have algorithms that decide the dispute without the necessity of a company customer interface at all. So I believe that 1 in 6 million or something comes up for a company customer interface. Otherwise, those disputes are resolved completely online by their algorithms. That is one form of dispute resolution. The other is, using online platforms for, convening the meetings and conducting the sessions. And this is where even the ADR institutions need the ODR platforms for conducting this. The third thing is the case management platforms, because for the case management, that's again, where the ODR institutions like JustAct, there are various other institutions that can contribute. IAMC has now tied up with JustAct, for instance, to launch the case management platform for managing our cases. And that integrates both the online platforms as well as, the in-person meetings. So the case management is done completely online. So the uploading of documents, the scheduling of hearings, the exchange of information, all that happens online in a very seamless method. And if any offline discussions or meetings are required, the institution provides the venue for those. So I don't see these two operating in silos. I see an integration of both these things together, both the ADR institutions and the ODR institutions. The ODR institutions may retain their autonomy, their identity for resolving the disputes that they want to. At the same time, they can work with ADR institutions in providing the platforms, providing the frameworks, because they have the expertise which they can offer to the ADR institutions to make use of, to streamline and to make the dispute resolution process more efficient and more effective. So that's how I see that integration happening in the future. I'm sorry.
Thank you, Justice Gupta and Jawad. Um, so on just staying on this topic, the MSME sector, which has its own specialized way of resolving disputes. There is a framework in the MSME Act, where the dispute is taken to a facilitation council. We find that the ministry has introduced AI and an algorithm which is a pre-facilitation council level at which the disputes will be resolved, where they get the assistance, the information is shared, and they get the assistance of an algorithm which tells them this is how the dispute is likely to end up being resolved. And following this, there is a negotiation stage where, based on the information given by the algorithm or the outcome proposed by the algorithm, parties are encouraged to negotiate and see if they will resolve their disputes. This is purely voluntary, right? Both parties need to agree to this. So now you have AI doing much more in resolving disputes. It is suggesting outcomes, it is assisting negotiations. Where would you personally draw the line on how much AI should do? At what point do you feel that AI stops being a tool? Do you see any integrity issues? Do you feel that there must be an element of the human in dispute resolution? What are your thoughts on where this is progressing in India?
No, Chitra, ODR can possibly use AI because they have similar disputes, like conveyance loan or a house loan. The problem would be almost the same: an ability to pay, or some ability or some difficulty to not to pay. But other than the similar cases, probably AI will not be useful. It should not be used, because the AI, what is AI? It collates the data from the sources which are already available and applies that. But the disputes of other nature, which are not of any routine kind, requires human intervention. Without that, you can't get a proper decision. So ODR is relevant partly for similar cases, similar situations, but not for other than similar cases.
This is a very complex question, actually. Just to add to whatever Justice Hemant Gupta said, uh, there are three ways that AI can play a role, Chitra, from what you asked me. The first one is where it can assist you for purely a clerical job, summarizing documents, collating information. So that part of it. The second is, augmented AI, where perhaps AI can be used to explore different options, to, suggest solutions, to explore potential outcomes, like how MSME is using it. So that is one part. The third part is where automated AI, where the AI itself is the neutral, either as a mediator or as an arbitrator. Now, insofar as the first two are concerned, it can be a purely consensual process where, with permission of the parties, a neutral can utilize the AI services to even suggest any possible outcomes, to explore different options, to perhaps do a reality check of the parties' perceptions. So in this aspect, I think AI can be used, for which we don't really the existing regulations, the existing rules will be sufficient to deal with that aspect. The challenge comes when we talk about automated AI, where the AI is going to be replacing the neutral, whether the mediator or the arbitrator. Now, here there are two challenges, because one is the AI bias and the other is the AI hallucination. Now, I don't know how technology is going to evolve. When we talk about this situation, because you're not talking about five parties. The disputing parties are the two parties. The third party neutral will be one party. The ODR platform that you're going to be using will be the fourth party. And the AI programmer will be the fifth party. So what kind of biases are being injected into the AI algorithm, how it is going to look at issues, whether it can really replace a human mediator or an arbitrator. The future alone can tell how this is going to evolve, what kind of technology we are going, because every day we see some change or the other, some new development or the other happening. So we really don't know where we stand today. Now, I read somewhere the American Arbitrators Association is using AI as an arbitrator. Now, what kind of regulations they have brought in place for that? How do they, deal with these issues of bias and hallucination? I think I need to study that a little more. To be honest with you, I haven't studied that very deeply, but that's something that we should be definitely interested in exploring and finding out how they're dealing with that aspect. So, but I would agree with Justice Hemant Gupta when he says that complex disputes cannot be left to algorithms to resolve. We can use them only up to the level of maybe assisting us in exploring ideas, or to test realities, or to test perceptions, or to maybe provide us with some information on potential outcomes. So when it comes to complex disputes, I don't think AI should be replacing the human mediator. When I was asked this question in a university, that I'm okay with AI with all these things, but until the day comes when I can take Alexa or Siri on a date for a cup of coffee, I would still prefer to have a human mediator or a human arbitrator dealing with my dispute. So that's what I would like to say about this. but there's a big future out there. We don't know how it's going to evolve. So it's too. I think what we say tomorrow may not be relevant today. May not be relevant tomorrow.
Yeah,
So that's how I see the evolved landscape there.
yeah, absolutely. There are concerns about using AI in complex disputes, and the uncertainty of it all and the speed at
No, we'll need a whole new set of rules and regulations for that.
yes, that's right. Yeah. Thank you for that. This was a question I wanted to ask Justice Gupta in the earlier session, and on mediation, I probably will ask it now. When it came to arbitration, India adopted international conventions with a fair amount of speed. The Geneva Convention and Protocol of 23 and 27 was adopted within a decade. When it came to the New York Convention, we adopted it in our Foreign Awards and for Recognition and Enforcement Act 1961 within a few years. We have the Singapore Convention, and we are in a context where our standing in the international arena as a place for resolving disputes, the ease of resolving disputes that you referred to, Justice Gupta, in the earlier session. This is something that we in the country are concerned with. So do you think India should ratify the Singapore Convention soon? I am qualifying it with soon. What do you think are the advantages, or the benefits that we would get with the ratification?
Chitra, to be honest, I have not gone through Singapore Convention on Mediation. I have gone through this Singapore Convention on Insolvency Mediation. But I won't be able to comment. I leave it to Jawad to answer this.
Yes, sir. If you could give us a few thoughts on mediation and insolvency, I think we will be grateful for that.
No, the Singapore model is come to us for mediation in insolvency proceedings. It is their marketing model. Why should India get trapped into it? That's what I. There was Chitra. I remember there was Justice Kannan, who is a judge of Singapore Supreme Court. He was visiting India and he met me. They were propagating that there should be mediation in an insolvency proceeding. That they have, he brought a declaration, Singapore Declaration. But when I read it, it says that come before us, we'll do this, we'll do that, which I probably, personally speaking, I will not prefer that.
In fact, sir, the IBBI had set up a committee to examine whether mediation could be used in the context of insolvency resolution, corporate insolvency resolution. In 2024, they found some difficulties, and they felt that the use of mediation in insolvency resolution, we need to work out a framework and a policy that is specific to the insolvency resolution process. That's where it stands.
But mediation, according to personal opinion, mediation is best suited in all commercial matters. Because commercial matters is give and take. Take 1 rupee or take 50 paisa or something of that kind. Except where there is the egos comes in. In corporate insolvency, there would not be any ego. There will be, basically, it's all money dispute. Non-payment of the money, it can be better resolved by mediation. Personal opinion is like that. But Jawad is much more involved in mediation. I think I leave this question to him to answer.
Thank you, sir. Actually, more than me, I think it's Chitra herself who's an authority on the Singapore Convention itself and it's what it means for India. So I would be playing it safe actually by asking her what her opinion about this is. But all I would like to say to answer her question, I think, is that having signed the convention as one of the first signatories, when the convention itself was passed in 2018, I think, I don't see any reason why we are delaying the ratification of the convention, because it creates, at least in terms of perception, as a good place to conduct arbitrations. Though it has nothing to do with conducting arbitrations, it's more about the implementation of the mediated settlement agreement that is reached in cross-border disputes. So it deals more with that. But I don't see any reason why India should not ratify the Singapore Convention. And I think it's very important for us to do that, because that will create a whole level of credibility in the minds of international investors and people who are using India as a base for conducting their businesses or for making investments. Because if we say that we are not going to be ratifying the Singapore Convention, or we are not even saying that, but we are just keeping quiet about it, we are not expressing any perspective or any point of view. We just signed it and we're just keeping quiet. And in fact, our Mediation Act itself effectively takes us out of, in its definition of international mediation, I think, in my point of view, it takes us out of the purview of the Singapore Convention. Because when you make a settlement agreement enforceable like a decree of the court, even in international mediations, then it goes effectively out of the Singapore Convention. So I think we need a big rethink on this, and we need to really, bring about a law that would recognize and ratify the Singapore Convention. It's high time we do that. We have delayed it long enough. From 2018, I think it's now almost 8 years now, right? My maths is a little bad, but correct me if I'm wrong. It's 6 years or 8 years? 8 years, to 2026, yeah. So there's no reason for such a long delay on our part. I think we should ratify that.
Thank you, sir, and Jawad. The TK Viswanathan committee spoke, in their report say that more than 90% of all domestic arbitrations are ad hoc arbitrations. What can we do to take more cases to institutional arbitration and away from ad hoc arbitration? How do we encourage parties to use institutional arbitration?
We have to make Arbitration Act, the 1996 Act, in such a way, because you can't do away with ad hoc arbitration by statute now. Only thing is that you prefer institutional arbitration, like you have Appellate Arbitral Tribunal, take powers of the court, Section 9 can be taken away. There's an institution can have emergency arbitrator. Section 8 can be taken, because if there is an arbitration agreement, why there should be intervention of the court. All these things should be done in an indirect way so that people prefer institutional arbitration. They find it more effective way of dealing with the dispute resolution rather than the ad hoc arbitration. Ad hoc arbitration is small disputes. It can be decided by way of without the intervention of the institution. We have to create that environment. Even the execution of the award, if it is given to the institution, even that will be a factor to promote institutional arbitration. These are small steps which will probably create environment in favor of the institutional arbitration.
Thank you, sir. Jawad?
Chitra, yeah. See, I don't see any reason whatsoever for people not to choose institutional arbitration, except for two factors. One is perhaps the lack of awareness of the advantages of institutional arbitration. And second, the wrong perception that it is going to increase their costs. If you look at the cost factor, actually, in an ad hoc arbitration, you're spending a lot of money in filing Section 11. You're spending a lot of time in waiting for the appointment of the arbitrator. You're spending a lot of time in hiring a venue for conducting the arbitration. So there are a whole lot of hidden costs that are involved, which you don't realize. Whereas the poor institution only charges you an administrative fee. That's the only revenue that comes to the institution as such. The rest of the money goes to the arbitrators. So for that administrative cost, what does the institution do for you? It makes the whole process absolutely efficient and expeditious because you don't have to wait for months together to get an arbitrator appointed. If you have an institutional clause, you can get an arbitrator appointed in quick time. You have an entire case management system in place with professional case managers who can guide you through the whole process of arbitration, saving a lot of trouble not only for the clients and for the lawyers, but also for the arbitrators. And you have a venue where you can conduct the arbitration. So a venue that has all the amenities and all the facilities, including for video conferencing, for proper conduct, in a professional setting, because you don't get that kind of a professional. We had one senior advocate who visited us recently, and he said that this has a really professional, feel about the whole. So all this is done in a very professional way. So there's no reason for people not to choose institutional arbitration except the lack of awareness. And I think it is, I think for the lawyers who are advising parties when they are drafting the contracts, I think the job is for the transaction lawyers to advise their clients to include institutional clauses in their contract so that there is the advantage of using the institutions effectively for conducting the arbitrations. And the whole process becomes totally efficient. There are timelines that follow that are adhered to. There are fee schedules that are adhered to. There are rules that are clear-cut and transparent. So you know what exactly you can expect when you go for an institutional arbitration. There is no vagueness. There's no, and there are no imponderables that are there. So considering all these advantages, I don't see why people should not choose institutional arbitration. And of course, one of the things that I fully agree with what Justice Hemant Gupta said. I think there's a lot of policy decisions, legislative changes that have to be brought about. I think the 2024 amendments might be game changer in in popularizing institutional arbitration.
Thank you, Jawad. Thank you, Justice Hemant Gupta. Talking about the proposals that the 2024 amendment bill makes, there is a provision for, in the case of institutional arbitrations, for an appellate arbitral tribunal. Do you think we are rejudicializing the arbitral process by, having so many tiers in the arbitral process itself? What are your views on this proposal?
Actually, I look at it from a different angle. Section 34, as of now in court, has a different tiers. And there is except in metros like Bombay, Calcutta, or Chennai, there is the metro goes to the principal civil court. Then it comes to the High Court under Article 226 or 227 and the specially petition. The Appellate Tribunal will facilitate that stage, because people will not be required to go to the Section 34 before the principal district judge. So that is one level is taken care of. And since if the Appellate Tribunal is trustworthy or it creates confidence, even the interference by the High Court under in exercise of judicial review and the Supreme Court will get reduced. It will give finality to the award at much faster way rather than the court channel under Section 34, 37.
Thank you, sir.
It's a matter, this is a procedure which is worth attempting. No, we want to jump at the conclusion today that it will not work out. So it's if once it is at place, we can learn from the experience and make corrective steps at the later stage according to the situation so warrants.
And so would you think that then the appellate tribunal would have wider grounds to evaluate the award than Section 34 court?
No, it will depend upon the statute what the conditions are. But generally speaking, it should not be an appellate jurisdiction like that of a in the civil court where the law and facts both are open. It's only the errors of law probably can be examined. Maybe that way. I'm not very sure that how the jurisdiction of the appellate tribunal is circumscribed.
Yes, sir. Thank you. I think you make the point that in the appellate tribunal, you have the advantage of focused and expeditious attention to what the award is. And therefore, that eliminates successive challenges in the court system.
That's what I feel. Thank you.
Jawad?
I fully agree with whatever Justice Hemant Gupta has said, because one of the we are forgetting what is the core underlying principle of arbitration. It's all about party autonomy, the right of the parties to bypass the judicial system, choose their own forum to decide the dispute. Okay, so that it can be done expeditiously, it can be done in a flexible manner, which would suit their needs and which would help them to resolve their dispute much quicker than what would happen in the courts. But unfortunately, our statutes are designed in such a way that judicial intervention has been maximized instead of being reduced. So I think the appellate tribunal will be a concept that would actually implement the core underlying principle of arbitration, which is, essentially respecting the rights of the parties to choose a forum that is not a judicial forum. So having said that, what I would like to emphasize is what Justice Hemant Gupta said, that I think the mandate of the appellate tribunal should be very clear as to what exactly the appellate tribunal is going to be looking at and what will be the powers of the appellate tribunal. So once a party chooses an institution for conducting the arbitration, which means that they have agreed that the arbitration rules, the institutional rules will be applicable to the resolution of their dispute. So they have gone through the rules, they have understood the rules, and they have agreed that these rules we will follow. So therefore, when an appellate tribunal is constituted by the institution, which means the parties are agreeing to go before the appellate tribunal. So there's nothing wrong if the law itself provides for that. And that would actually, prevent the flood of cases that come, before the courts under Section 34. Right. So the mandate should be very clear. The rules should be very clear. I think once that is done, I think it is a very good idea to have an appellate tribunal within the institutional framework itself.
Thank you, Jawad. I'll go to the questions in the participants forum, the questions that have been raised there. How safe is arbitration in technology related to AI regarding the data and the documents asked and shared is Nazim Kachi's question. Either or both, if you could respond.
I think I will leave it to Jawad because he's expert on AI and related issues.
Sir, honestly speaking, I'm not an expert. I see Madhav on the screen. I can't think of a better person to answer that question because that is exactly what we were discussing when we signed the MOU with JustAct as to how safe the documentation is. But I think there are different layers of security, am I right, Madhav, that are implemented to ensure that in terms of the access to documents and to the access to information, that is limited only to those who are actually having the necessary code, whatever.
Madhav, please.
But we are yeah, I'll just ask Madhav to add. One thing I just want to say before I hand it to Madhav is that anything can be hacked into today. Okay, so the concept of privacy as we used to understand it before the technological age set in is an illusory concept today. There's no such thing as privacy because if you look at some product in Amazon, Facebook will show you 100 ads about that product. So what kind of security are we talking about? But having said that, insofar as the online platforms are concerned, I think they are sufficiently. They have different layers of security that are provided. Let Madhav explain that.
Madhav, would you like to do that?
Yes, thank you for having me while the conversation is going on. Basically, like Jawad sir was saying, all the portals are password protected, first thing. And to add to layers of security that are already existing on the servers, we go through an extensive ISO certifications or information security certification. We have vulnerability and penetration testing that is carried out by a third party experts and on a yearly basis, and we are given the notes on how to improve our security protocols on the platform. And from time to time, at every interval of, let's say, 1 year or 2 years, we keep upgrading our security system that we have to ensure all the documents are safe.
Thank you, Madhav, for that. I think what you have shared is very important. It is an important question that has been asked and that you've readily responded. Thank you very much for that.
I think just to add to what Madhav said, I think there are encryption software in place, if I'm right, Madhav, and there are firewalls that prevent people from hacking into the systems.
Yes, sir. It's a AES 256-bit encryption, sorry, that is existing. Yeah.
Thank you so much, Madhav. There's a comment here. I think it's a comment from Kunal Vinayak in a lighter vein to Jawad. When will IAMC be conducting an arbitration training program for men now? Okay, there's one more question that I want to take. There's a question to Jawad. For a high volume loan recovery mediation, what do you think can be a process blueprint?
For a high volume debt recovery.
Yeah, for a high volume loan recovery mediation, what do you think can be a process?
I think basically the process of mediation. One thing I want to emphasize is that mediation is not procedure driven. It is more process oriented. So it's for the mediators to evolve a process depending on the kind of dispute, the buyer, what is the nature of the dispute, to evolve the process according to that. So when you talk about a loan recovery, there are many facets to a loan recovery. So for example, something that we don't get into when we are perhaps adjudicating the dispute would be, what are the factors that prevented the debtor from settling the dues? Was there anything that happened for the debtor that was not within the control of the debtor? So those aspects can be explored, and perhaps the finance company can see how they can help the debtor to be able to repay the loan, or to maybe restart a business. Possibilities are there. Instead of just treating it as a default and recovery issue, you can go a little deeper into the various other aspects that are involved, the human element of the dispute. And just to give you an example, in one dispute which was filed by a non-banking financial company against a debtor, the collateral security was tied up in some litigation, and the debtor very well knew that they cannot recover the money from him. So he said that I cannot pay the money. Then I asked him in a private session that what are your future plans? He said, I'm planning to start another business. So I said, how are you planning to get the funding? He said, I'm going to approach the banks. Then I asked him, are you aware of the CIBIL scores and all that, which finance companies and banks look into to see your credit worthiness? He said, no, I didn't know that. And I said, if this default reflects on your record, do you think you'll be able to get a loan from the bank? That suddenly dawned on him that, yes, it's important to settle the loan. So then there was some negotiation on what should be the settlement amount, and based on his capabilities and all that, it was discussed, and finally we reached a settlement. So mediation being a very flexible process, it can find different solutions. Like for example, in one case where there was a default, the company offered potential in the business, and they realized that the default was not on account of the debtor's fault, but because of certain factors that happened, which prevented him from repaying the money. So they agreed to give him additional funding to help him to restart the business and to deal with the contingencies that he had to face. So you can come up with some, very flexible solutions and, innovative solutions, which out of the box solutions that normally an adjudicatory proceeding may not permit you to. So this is the kind of flexibility that you have. Ultimately, your goal is to recover your money, not to punish the defaulter, right? So if that is your objective, then you can think of very creative solutions on how you can achieve your objective through the mediation process. That's what I would like to say.
Thanks, Jawad. The examples you gave show, that it's not blueprint driven, but really the individual situation and what, bringing out the human element, as you call it, in these situations to see where there can be possible settlement. Thank you for that. I think I'll just take this one last question from a participant. The question is on Section 34's patent illegality thin line. What drafting clause in ODR agreements avoids judge-made public policy challenges in loan awards? May I read it again? Because it's a lengthy question. On Section 34's patent illegality thin line, what drafting clause in ODR agreements avoids judge-made public policy challenges in loan awards? Can parties draft around what would not be regarded as patent illegality or frame patent illegality? Maybe.
My answer would be that the parties by agreement cannot override law. So probably the legislature had to come forward that in certain low volume, low value cases, the award will not be challenged or challenged on ABC ground. That is one way, but to say that patent illegality will mean something for ODR, that may not be permissible.
Thank you, Justice Gupta. Jawad?
I mean, what Justice Hemant Gupta said is absolutely right, because you cannot really contract out of the statute. You're bound by the statute. So patent illegality is always something that for the court to interpret and see whether there is really a patent illegality. But I think where the integrity of the arbitral awards comes into question, I think the scope should be narrowed down legislatively to ensure that there are no... See, today what has happened, as Justice Gupta also earlier pointed out, virtually every ground that was there under the 1940 Act has been imported into the present Act under the guise of public policy. So it has expanded the scope of challenge to arbitral awards. So there, I think there should be some restriction, because again, the party autonomy, parties have chosen the forum, and unless there is a totally perverse, award based on absolutely non-existent evidence or whatever, I mean, something like that, I don't think awards should be lightly interfered with. So I think this is where I think the judiciary has to draw the line. And impose some, self-imposed restrictions on how they are going to be interpreting the awards. Otherwise, then the whole purpose of having an arbitration agreement, going in for an arbitration, is defeated completely if you're converting it simply into an appeal against an award, just as you file an appeal against a judgment and decree. So the whole purpose of the arbitration process, of arbitration law, the arbitration contract itself gets defeated when you expand the scope of challenge to arbitral awards. So there should be some manifest perversity in the award that would really warrant interference by the court. Okay, so there should be proof of corruption. There should be proof that there was absolutely no material for the arbitrator to come to such a conclusion. So unless that kind of, legislative change is brought about, and also courts start imposing a restriction on themselves on how far they're going to be interfering with the award. It cannot be that you go for review and then you go for curative petition and then you set aside the award which has been confirmed already. It cannot be that way, okay? Because that loses it makes people lose their faith in the whole system itself, and the credibility of our whole ecosystem gets questioned, and that's where foreign parties hesitate to come here to use India as a seat of arbitration. That is one aspect. The other aspect, I just wanted to add, though it is not, the question is not asked. I recently read a report. In Bombay, the stamp duty rules have been changed to such an extent that, for example, if you have a 1 crore award, you have to pay a stamp duty of 87,500. So that needs to be rationalized. Whereas in Hyderabad, it is only 200 rupees for an award, regardless of what the amount is. So these are all, some legislative and policy-oriented changes that need to be brought about to really make India a global hub for dispute resolution. Until then, it is only talk. We are not taking it seriously. We are not doing anything seriously. So let's not talk about it.
Thank you. Thank you. I think we're running out of time. I want to thank Justice Hemant Gupta and AJ Jawad for participating in the inaugural webinar in this series. We're deeply, deeply grateful that you have shared your time and your expertise with all of us. We take your message very strongly that it is all of us as a team who are the future of arbitration in India. Thank you also to the participants. You've given what might have been a day of leisure. You've given 3 hours to this webinar, and we are also grateful to you. Wishing everyone a nice weekend and a fruitful week ahead. Thank you.
Thank you. Thank you, Chitra.
Thank
It was
you.
wonderful interacting with you. Your questions were quite incisive, and you got probably the best or the worst out of us.
Thank you, Chitra, and thank you, JustAct, and especially for the honor and privilege of sharing this stage with Justice Hemant Gupta. It's a big honor for me to be with him today on this panel and to be discussing all these things with you. And I only hope that I haven't put my foot in the mouth, which I normally tend to do when I speak. So thank you very much for all the patience and all those incisive questions which both Chitra and Aishwarya asked in this session. Thank you.
Thank you.
And best wishes to JustAct.
Thank you, sir.
Thank you very much, JustAct.
Thank you. Thanks, everyone. So, like we have witnessed the last 3 hours, we consume information in many forms, but rarely do we get an opportunity to hear it in a place, in perspective, by people who have spent decades working on the ground, shaping and building this field from within. Today's webinar was one such opportunity. Both our panelists and moderators brought with them the decades of experience, and what stood out was the candor and depth with which they shared their views. The discussion spanned some of the most pressing themes shaping the profession today: the role of AI in the legal landscape, growing importance of mediation as an effective dispute resolution mechanism, and the continuing conversation around gender diversity in the legal fraternity. While progress has certainly been made, it was also acknowledged that representation of other genders still remains largely absent, reminding us that there is much more work to be done. A message that came through clearly was this: if India is to truly emerge as a global hub, it will require more than conversations on stages and podiums. It will require consistent effort, collaboration, and a willingness from all stakeholders to actively contribute to the building of the future. Conversations like these do two things at once. They reinforce what we think we know, sometimes adding depth and sometimes gently correcting us. At the same time, they open us up to perspectives we may not have considered before. This is rare and deeply valuable. And of course, there were lighter moments during the conversation where Jawad sir jovially remarked, perhaps the day isn't too far when we might all be waiting to take Siri and Alexa out for a coffee. A reminder that while technology continues to evolve rapidly, the human element of the profession will always remain central. It was indeed a privilege to have Justice Hemant Gupta, Jawad sir, Chitra ma'am, and Aishwarya with us today. Thank you so much for your time, your insights, and the generosity with which you shared your experience. And to everyone who joined us, thank you and have a lovely weekend. Thank you from JustAct. Bye-bye.